The Supreme Court is going to be holding 3 days of hearings next week on the constitutional challenge to the individual mandate portion of the health care reform bill, also known as Obamacare. But before they even get to that, there's an obscure challenge called dealing with the Anti-Injunction Act. Could you explain the Anti-Injunction Act issue to our audience and explain what the argument for it being applied, which would bar the Supreme Court from hearing the challenge to the individual?
This is a little unusual. Everybody gets worked up over this case and go, wait, we mean whether are they going to be able to even take it up? This is a jurisdictional issue, at least in the mind of some, which means the court can raise it on its own, even if the parties haven't. A law in the 19th century, actually 1867 was the first version of it, was passed by Congress. It essentially says that the administration or collection of a tax cannot be challenged and interfered with by a private person in court before it actually goes into effect. Now, there have been a lot of older cases on this, but the argument that came up and was succeeded in some of the lower courts, one of them in particular was, well, you can't hear this case until the individual mandate, which is enforced by a penalty, which is collected through the Internal Revenue Service, actually goes into effect in 2014 and someone is forced to pay it and then can challenge it. The court doesn't have jurisdiction to this. That succeeded in one lower court. Most of the other courts looked at this and said the whole history of this law and this mandate was they went out of their way in Congress to do all kinds of things to say this is a penalty, not a tax, and they did it in a different way than you normally would collect a tax. They didn't have the same type of criminal penalties, the type of liens on your property, so it was kind of like a tax, but not really, somewhat like a transformer where politically you want to say it's a penalty, but for legal reasons you want to say it's a tax. So we'll see how the court handles this, but it's a complex issue which is a little puzzling.
So how do you think that will come out? How do you think the court will rule on this?
There are a lot of arguments that have been thrown up, but basically it'll come down to saying whether this fits the mold of what is the type of tax that has been banned from being a lawsuit being brought against it until it's collected. It's a matter of statutory construction. If you look at how the mandate was constructed in the health law and how similar provisions in the past have been interpreted as either a tax or not a tax, I think that the court will finally decide that they can go forward. This is a big case, and to say, wait a minute, just wait 2 years and we'll get back to you on this is probably not going to work.